Is it possible to settle your medical malpractice case after I have questioned the doctor whom you have sued in a pretrial deposition? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you sued your doctor for medical malpractice. You claim that the doctor was careless and caused you significant harm and injury. The doctor, on the other hand, says, no, I did nothing wrong. Why are you suing me? And then he says, you know what? Even if I did something wrong, so did you, Mr. Patient. And then he says, you know what? If I did something wrong, whatever I did not cause you harm and injury. And then the doctor says, okay, if I did something wrong and I caused you harm and injury, those injuries really are not as bad as you claim them to be. Those are the typical defenses we see when we bring a lawsuit for people who have been harmed by their doctor or careless hospital staff. Now, from the moment we start your case, the defense attorney reaches out to let us know that they have spoken with the doctor, and the doctor firmly believes that he did nothing wrong, so that there is no way possible they will ever negotiate or settle your case. Well, it's nice to know that at the very beginning, because oftentimes we don't get this feedback until much later in the case. However, in a number of cases, the defense lets us know right off the bat, listen, we did nothing wrong here. I don't know why you're suing us. I have no idea. Whatever injuries you have, they're not because of anything our doctor did. So now we go forward with the litigation process, which means exchanging documents. It's part of the discovery process, which means conducting depositions, which are pretrial question and answer sessions, where each side has an opportunity to question the various people involved in the lawsuit. These depositions are critically important to the lawsuit. Why? Because now the witness's testimony, the plaintiff, the injured party, now his testimony is being recorded by a court stenographer in pretrial testimony. The answers that my client gives in response to questions by the defense attorney represents his or her sworn testimony. And even though it's being done either in an attorney's office or on a Zoom video call, this carries the same exact weight as if they are testifying in court, in front of a judge, in front of a jury at the time of trial. So just because this takes place in what many consider to be an informal setting, either an attorney's office or on a Zoom video call, the answers that are given by the witness are critically important and form the entire basis for what goes on in this case. Now, the same exact thing occurs when I have a chance to question the various people whom you have sued, including doctors and hospital staff. Their answers during their pretrial deposition represents their sworn testimony. Many times at the very beginning of a case, there are missing pieces of the puzzle. We don't know about certain conversations that occurred between various parties to the lawsuit. We don't know about information that may not be contained in the patient's medical records. We may not know about an email or a text that went on between a doctor and a nurse, or a doctor and a physician's assistant, or a doctor and his partner. And only through the discovery process do we learn this information. This is a slow and deliberate process that allows us the ability to try and obtain as much information as possible about what occurred and why. Now, let's go back to the question that I asked. Is it possible to negotiate or settle your case after the doctor's deposition has been done? And the answer is yes. And let me tell you why. Remember, I told you a little earlier that in many cases, the defense attorney comes to us and says, listen, we did nothing wrong. We have no intention of negotiating or ever settling this case. We'll see you at trial. Fine. Now we proceed through the entire litigation process. And that can take anywhere from 2 to 3 years from start to finish. There are instances, however, where as we continue questioning the various witnesses involved, we learn more details about what occurred and why. Each side has limited information. We know what our client has told us. We know what's contained in the medical records since we've obtained that, reviewed it, and had experts review those records. Likewise, the defense has had an opportunity to review those same records. We go ahead and give permission slips to the defense so they can get those same medical records. They will get them, they will review them, they will have their experts review them. And of course, they will speak to their clients to learn from their viewpoint, from their perspective, what exactly happened and what occurred. So now, during the course of the lawsuit, when each side is questioned, they're going to learn more details and more information about the specific events that involve this particular lawsuit, involve these claims. They will learn information from my client about those things that she can and cannot do, those things that she's unable to do now or does with difficulty. Now, after my client is questioned, I will have opportunities to question the defense, the defendants involved, the doctors and the hospital staff. During the course of questioning, I may learn information that could be favorable to us and not so favorable to the doctor and the defense. In that instance, where the information that I learn from various doctors and hospital staff is favorable to us, after I am done questioning that particular witness, I will oftentimes have a conversation with the defense attorney and say, listen, it's quite obvious what happened here based upon this doctor's testimony. And now, if that information is favorable to us, it gives me greater leverage and greater opportunity to have a settlement discussion with the defense lawyer and say, look, based upon this new information that none of us knew about beforehand, it's quite clear and obvious that the doctor deviated and departed from the standard of care. And as a result of that, my client suffered significant harm and injury. And now we can have a real honest discussion between the attorneys about whether or not that's true. Obviously, they're not going to throw their hands up and roll over and say, of course, yes, you're right. How much do you want? What amount of money do you want on the check? I can write the check out right now. No, it doesn't happen that way. Instead, what happens is I have this conversation with the defense attorney. Now he will go back and talk to his doctor. He will talk to his experts, and then he will have a conversation with the doctor's insurance company. And if, in fact, this new information is so compelling and so clear-cut that what we are claiming is more likely true than not true, then it is quite likely or quite possible that now the defense attorney will reach out to me after those conversations and say, listen, it turns out that you're right. This new information is clearly not helpful to us. We'd like to start negotiating. In that instance, to answer the question I raised in the title of this video, yes, it is possible to settle your case after the doctor's depositions. Does it happen often? The answer is it does not happen often, but it does happen from time to time. Why? Because we learn new information during the course of discovery that will help us begin to negotiate. And now, after this new information has come out, now it gives us a leg up, it gives us more leverage, and now we can have a better negotiation conversation with the defense that may in fact lead to a settlement. Why do I share this quick information with you? Because I had a few minutes to hopefully share with you exactly what happens in these medical malpractice cases in New York. You know, I realize that you likely have questions or concerns about your own matter. Well, if your matter happened in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.